Okay, thank you. Good evening, ladies and gentlemen. My name is John Leonard. I'm chairman of the Board of Appeals. This is a continued application hearing on the application of H&W Apartments. The original application was, we had a hearing on it about a week or 10 days ago. I don't have that file in front of me. December 2nd. Thank you very much. With me this evening, as we're present at that last hearing, to my immediate right is board member Virginia Donahue King, and to my immediate left is board member Jeffrey Mullen. As you'll remember from the first hearing, I was suffering with an intemperate voice at that time. I'm a little better, but not much. So if anybody has any difficulty hearing us, please let us know, because it's important that you hear everything that's being said. The purpose of this hearing was in response to a comment at the end of the previous hearing by Attorney Whitten, who's present here this afternoon, together with Attorney Kathleen O'Donnell, who's special counsel to the town of Milton. They thought that their view of the evidence indicated that the town of Milton had satisfied one or more of the criteria set forth in the statute and the regulations, so that this project would not necessarily have the ability to proceed as a 40B project. And they indicated that they were going to be filing materials with the board prior. We asked for the materials to be submitted on the 9th, and the town, I think, was a little bit delayed in getting those materials to us. In the interim, we did receive a filing from Attorney Caggiano, who was present at the last hearing, representing H&W Apartments, as well as from his partner, Attorney Nicholas Cram, who's here this evening. So good evening, Mr. Cram. Good to have you here. That filing included a letter dated December 9th to Mary Fitzgerald, the clerk of the board, setting forth the applicant's position. It also included a site plan document for Milton Fuller Housing project, certified by former clerk at the time, Jim Mullen, and it also included a letter of December 9, 2014 to Mrs. Fitzgerald and the board with respect to the issue of the Milton general land area minimums, and setting forth VHB's analysis as to whether Milton complies with the regulation or whether it doesn't. This particular study was performed by Ralph W. Wilmer and his colleague Renee, I think it's Guo, who's a project planner with VHB, and their resumes are attached. So we certainly have that as part of the proceedings this evening. So I should just mention very, very briefly that this is a limited hearing dealing with this particular issue, as whether the town of Milton has achieved the 1.5% land area established by General Laws, Chapter 40B, Section 20. And we'll keep it limited to that with a couple of other very small procedural issues. And we're going to try to keep this hearing less than an hour if we can. We will go over if we have to, because we don't want to suspend this hearing. We really don't have much ability to do it. But the board does have a full schedule of hearings at 7:30 this evening, so we don't want to put ourselves in an awkward position there or to delay those hearings. I should just mention, as I customarily do, that the hearing this evening is being tape recorded on Mrs. Fitzgerald's little mini recorder here. The acoustics in this room are not strong, and so that would ask that before anyone speaks, tell us your name and address, speak up loud and clear, so that if we have to revert to the tape recording in order to write a cogent decision in this case, we'll be able to understand who's speaking and have the benefit of that. So with all of that a preamble, if we have nothing else to add, why don't we introduce Ms. O'Donnell and see if...
No, go ahead, I'm sorry. Just a minute.
Oh, sure. And see if you wish to be heard. We also have John Whitten here, and perhaps, I don't know the order in which you want to be heard, but whomever wants to speak first, we're delighted to hear from you. We also have present a familiar face at the table, and that's our town planner, Bill Clark. So,
Thank you very much, Mr. Chairman. As in assistance with Mr. Clark and the town staff, as we mentioned at the last hearing, we believe that the town has the benefit of two, probably, statutory minimum to consider in whether or not it wants to proceed with the applicant's comprehensive permit. The first one being that 1.5% of the land area of the town is already occupied by affordable housing. And the second would be the town's progress on its housing production plan. The town has a housing production plan that was approved in October, but had submitted units for approval at Fuller Village. Those have now been added to the SHI, and so we believe that not only have we satisfied the 1.5% statutory minimum, but that we have also made progress on our housing production plan, and therefore would be allowed to postpone, as I said, this application and any other 40B application for another year. As you know, you've gotten the information, sort of a rebuttal letter. Actually, I think the rebuttal letter probably arrived before our actual figures.
it didn't, but not a surprising thing when you have mince letters.
So it's always
involved.
tough
You're
to
always
have a
ahead of the
rebuttal
ball.
come in before you've submitted the draft. You know, as we have said, with the assistance of the staff, and I think we now have a map, we have done much.
Could I ask you, has this been provided to Mr. Caggiano and Mr.
Yes,
Tran?
I believe so,
Okay,
yes.
Thank you.
And-
As well as the letter, the proposed letter.
Yeah,
Okay.
yeah.
Great.
And I had discussed it with Mr. Caggiano and Mr. Cram, you know, on the phone as well. Because they were working with my very preliminary scratched pencil markings on a sheet of paper. And so we are now in sort of a much better position to sort of have things that are typed, easier to read, and probably easier to figure out than what he was having to work with from last week. Apologize for that. What we have done are calculations on the properties that are already on the SHI. We have acreage that we have calculated based upon the addition of the Fuller Village, Phase 1 and Phase 2, and that we believe that at this point we have 93.825 acres occupied, square acres occupied by affordable housing, which exceeds the 1.5 that would be required under the statute. As you can remember from our discussion last week, the regulations just say that the board can consider using the statutory minimum and has to supply notice to the applicant 15 days from the opening of the hearing, hence this emergency meeting today. And so the applicant then can rebut that information, but both of those letters go to DHCD. And DHCD is the one that sort of looks it over and determines whether or not we've made a mistake or miscalculated, or can consider the materials on either side. So the regulations don't assume that the board here is going to be making that determination, but that DHCD will be making that determination. So as I said, we would suggest that the board be doing a letter to DHCD outlining both claims. One, that the 1.5 has been met, and giving the figures that we've supplied as to how much has been excluded and how much should be included. And that secondly, we've made progress on our housing production plan and would be allowed to defer the application based on that. Second.
Yeah, let me just ask you a question about the second portion of your argument. Where, other than your statement, where is the evidence on the progress on the housing plan that you want us to submit? Because I tend to agree with you. If we proceed, we're going to submit the materials that you, as special counsel for the town of Milton, deem probative on this particular application. Thank you.
So our chairman of the Board of Selectmen, Kathleen Conlon, has submitted a letter to DHCD requesting certification of the housing production plan, which we have received back from DHCD on October 28th, that the plan was approved. And then,
Mr. Casciano.
what?
Go ahead.
Do you have a copy from Mr. Casciano?
The plan has been certified, it's been approved.
Right,
Do you have an extra copy of this letter?
that's yours.
And then the recent SHI has increased our units from 426 to 477.
I'm sorry, excuse me, I don't mean to interrupt, but there's some confusion in the ranks here, because I just gave counsel,
That's the same letter.
The same.
is it?
Yep.
Excuse me, I just want to be sure we're dealing with the same letter. It is indeed, thank you very much. Go ahead, Ms. O'Donnell.
So on the subsidized housing inventory, we have gone from 426 units to 477 units this year with the addition of the Fuller Village. So we believe that we have demonstrated the increase in housing production that's required under the plan, and that we would be able to claim that secondary statutory minimum as a basis for either denial or condition of the permit.
Okay. Let me just ask you a couple of questions. I'll see if my colleagues have any questions. Do you agree with me that, the correct procedure here is if the board finds that there's a preliminary basis that this issue being raised by the town is bona fide? That what the board will do is we will submit a letter to the department along with the materials which you're providing to us.
Correct.
And so just to be sure, that consists of these 2 pages, a letter of December 10, 2014. It's not paginated, but it is.
No,
it is in 2
If
pages.
you take that one, that's the letter. No, it's not. No,
This
there's a
is not a
letter.
letter, this is
This is your, yeah.
I don't know what this is. It's-
That's the letter that we would submit to you.
No. This is the letter that summarizes
Yes.
the town's position
Yes.
on this matter. But
And-
it's on the Board of Appeals stationery.
Well, because I had thought that you had asked last time for a draft, that what you were looking for was a draft of a letter that the board would send to DHCD.
Well, I didn't, but I don't mind.
So that's how I
I don't mind,
characterized
no, I don't mind looking at
My
at
misunderstanding.
drafts. But the point is, whatever form of letter the board sends to the department is going to include the materials which special counsel on behalf of the town and any other town board wants us to submit. We're not going to, the board is not going to summarize or argue the town's position.
Correct.
To the State Department. And as I understand it, and correct me if I'm wrong, we are then going to be submitting with a covering letter, it's an appropriate covering letter. It's going to have these 2 sheets. These sheets aren't signed by anybody. It doesn't indicate who they came from. Mr. Clark's signature isn't on these
I
materials.
think the issue was to take the one that says draft, which includes that stuff that's in your left hand,
Yes, sir.
and then
This
put
is
the
Mr.
map
Clark on
with
it.
that,
Put the map with that, okay.
with the one that says draft, because it is the same information.
That's on these.
Minus, take away the 2 pages on the front, take the letter and the map and submit it. It says the same thing. It's explaining
Well,
why
it
the
may-
letter's
It may
going.
be, but it makes it sound like the Board of Appeals has made some findings regarding these matters, and the board hasn't made any findings on these matters, other than making a preliminary finding that this application, that your petition has sufficient bona fides in the
Well-
mind of the board to proceed.
Mr. Chairman, the regulations say that the board shall provide written notice to the applicant,
Yes.
which would not be me.
That would,
So-
no, it would include the materials
Yeah.
prepared by you.
Right.
And all I'm trying to.
So
all-
I
No,
could-
please. All I'm trying to get to the bottom of this is what written materials do you want us to submit to the applicant and to the board so that we'll know we're on the same page? And from my understanding, it's these 2 pages, but unfortunately, these 2 pages don't say anything about the town of Milton. They're not signed by anybody.
Okay.
This map, which we certainly can submit, and this letter of October 28th, 2014. Those 4 materials. Now, I guess my question is there anything else that you'd want to... So is it true that the town is not submitting any memorandum or any argument or... Except what you put forth
Well, the
here.
regulations are pretty basic about what needs to be submitted, which is basically based on the land area. So I don't think it's appropriate in the letter to DHCD to sort of be making some kind of legal argument, because it seems to me it's based on mathematical or arithmetic calculations. So
I hear what you're saying. You received Mintz-Levin's materials.
absolutely, and that's it, and that makes perfect sense that Ms. Levin would be giving an argument as to why we are wrong or incorrect or mistaken, and that's what they would be submitting to DHCD. I mean, essentially, they all they need to do is sort of redate their letter and address it to DHCD, and
Well, I think
that's
you're going to
their
find
letter.
they're going to do more than that, but we'll see.
But I mean, I can certainly, add a legal argument in there. They mentioned a case, Cloverleaf versus Natick. I know there's a case after that reaches a different result. I also know that there aren't any cases on these 1.5% argument since the new regulations in 2008. So I can certainly put that in the letter to sort of, reiterate the legal argument that somebody would be making.
No,
But I think the basic argument that we have is that we've done the calculations, we've excluded what we should be excluding, we've counted what we've counted, and that we have hit the percentage.
Look, you may be 100% right. I don't know. We all have our different styles, and the town can file whatever it wants. All I want to be sure of, and that's the purpose of the hearing tonight, because this letter has to go out promptly,
Yes.
is to just ascertain and be certain that the materials you want submitted to the department are this 2-page letter, as is. So they're not, this isn't a draft. This is what you want to submit. It's not signed by anybody.
We will put it on
not-
letterhead and have it,
So when are you going to do that? I thought you'd have that tonight. Is it going to be attested to by Mr. Clark, or? You can do anything
do that.
you want, but it just, this looks,
okay.
I don't know what this is. And I'm sure the department is going to say, I don't know what this is, and who did this, and when was it done, and how was it done? The foundation, whatever foundation you
Yeah.
want to put it in, but I'm going to write this letter tomorrow.
Okay.
Because I want to get it done. But what I certainly don't want to do, I don't want to leave out something that you want brought to the attention of the department. Because it's my understanding, and you correct me, because I think I don't do this work on a regular basis, and I have to say to my colleagues, I have a great deal of affection for them. This is a difficult area to be dealing with these regulations, and the legal and the social and political implications here is quite complex from my view. But I think that once the letter is sent to the applicant then has a period of days, I think it's 15 days to respond, and then it goes to the departments, and I think the department does not hold an adjudicatory administrative hearing on this. The department decides the matter based upon the papers that are submitted. It's like somewhat like a motion for summary judgment in a sense. So I just want to be sure that whatever arguments, case law, persuasive theories, whatever is to be raised here on behalf of the town and behalf of the applicant, obviously, is part of the record, because once that's filed, it's cast in stone, to the best of my opinion here.
Perhaps, Mr. Chairman, it would be helpful for Mr. Whitten to talk, since he's just gone through this process, that maybe he could weigh in on how the department handles these.
Mr. Whitten, welcome back to the board.
Thank you, Mr. Chairman. I'd be happy to. And I appreciate being able to speak, Mr. Chairman. I represent Joe Lombardi, 294 Highland Avenue, and I did raise this at the last meeting as an issue, and it's been confirmed by your special counsel and your town planner that you are over the 1.5%. The process is, as special counsel suggested, and as you have, Mr. Chairman, the board makes the statement, the applicant has 15 days to rebut, DHCD will make a decision. You're absolutely correct, there is no hearing. The hearing would be if either side chose to appeal DHCD's informed decision, and that becomes a de novo hearing before the Housing Appeals Committee, and I was at that matter today on behalf of the town of Stoneham, and Brother Hurley is representing the developer in that particular case, so he'd be able to discuss it with the board as well. That matter, or not,
Well,
right,
he's-
or not.
Be closed.
That matter then is heard by a hearing officer, and it's decided by the full Housing Appeals Committee. So I would just say, Mr. Chairman, if I could, the burden on the board, based on the material that I've seen from Town Planner Clark, has clearly been met. You're well over 1.5%. Mince's rebuttal, which is a rebuttal prior to having all the facts in front of them, they have every right to submit it, and I think the chairman showed a great sense of due process by even allowing this matter to take place tonight. But at this point, the facts are before the public, and I think it's now up to adjudication by DHCD, and an unsatisfied party brings that to a hearing officer. I can tell you, as special counsel said, that in the 1.5% jurisprudence, there are very few cases, the Weymouth case being the most recent. Mince's memo discusses earlier cases. Mr. Wilmer, who I have great respect for, discusses other matters, but frankly, they're not relevant, because what's relevant is the new regs, the new calculation methodology, and that is what the town planner has produced. So I would say, Mr. Chairman, the facts are indisputable.
Okay, and is it fair to say, Mr. Whitten, that on behalf of Mr. Lombardi, you don't intend to make any separate submissions or?
No, Mr. Chairman, and I appreciate the invitation, but frankly, and this is again perhaps a criticism of VHB and Mince, this is town data. I don't feel Mr. Lombardi could produce data that would replicate or contradict or improve upon the town's. It's your GIS status, it's your town planner. VHB can produce whatever fancy GIS programs they want, but they're not going to replicate the town of Milton's database, which is controlled by your assessor, your GIS expert, and your town planner.
Okay, great, thank you very much. Ms. O'Donnell, do you have anything further to add?
No, I do not.
Okay, let me see if my colleagues have any questions before we get to Mr. Caggiano and Mr. Graham. Mr. Mullen, do you have any questions of Ms. O'Donnell? Yes, sir.
So I want to be sure I know what we're looking at here before we send it off. Or before I just want to understand it better. We've got your letter, which says there are 13.04 square miles in the town, right?
Correct.
And those 13.04 square miles is shown on this plan, this map. Everything that's colored, that's the town. And whatever, that's readily available information, right? Mm-hmm. And then you've excluded property that's owned by the county, the Commonwealth, the town, water and rights of way in accordance with the regulation. So 56 acres are owned by Norfolk County, located in the town of Milton. Is that how I read this?
Yes.
Yes.
Okay. But they're not, you haven't articulated them on this map, right? Would those be in pink?
Those would be in probably the green.
The green. The
State.
green looks like Commonwealth to me.
Yeah.
The county and state are put together. They're under the green.
They're in the green.
They're green.
Yeah, okay. And the pink is more than town, right?
That would be town and.
Exempt.
Yes, permanent CRs.
Yeah, okay. And then you add those up and you get 3,555.97. Is it square acres or acres?
Well,
You're converting miles to acres. I think it should be acres, right?
yeah,
Okay.
square miles to acres, yes.
So, so then you break it down on this, so if it's 3,500 or so acres, non-constrained land, then you're saying you've got, on the SHI, you've got 93, it's really 93 acres, right?
Yes.
Yes,
And then you do the math of 93 acres divided into as many acres in as there are in 13 square miles. No?
No, you
Less
take-
than non-constrained.
Right, you take the.
Less than
You take
non-constrained.
the area available for development, which we think is 3,555, that's square, acres, times 1.5%. And that's what we have to have devoted to affordable housing, which would be 53.34 acres. So taking that figure, then down the list is what we've got, is the properties that we've listed are on the SHI with the acreage as shown on the assessor's map with generally what they're used for. And then adding all those together, we have 93, almost 94 acres, which exceeds the 53 acres that we think we have to have as 1.5%. That's how that breaks out.
And is the town saying to the board that this SHI eligible housing that's listed on this list, are those units, have they been either inventoried by the department or established according to the regulation as occupied and available for occupancy?
Yes.
They are. Okay, and is it, when you look at, so for example, 121 Central Avenue, let's just say, that's .4 acres, there are 8 rental.
Yep.
Is that, how do I understand it to mean for such sites, that proportion of the site area shall count that is occupied by SHI eligible housing units? Does that mean that 8 rental units occupy the .4 acres?
Correct.
And is that the full size of the lot?
That is the full size of the lot.
Are there any other units there?
I don't think so,
Okay. Okay, I think I,
because that's a housing authority.
yeah, I don't know the property, I just use it as an example.
Yeah.
Okay. Okay. I don't have any questions.
Could I ask you one more question here? The letter of December 10, 2014, or memo, whatever it is, we've just been given this third sheet. Is that a third sheet?
That's just a calculation. That'll show you the equation and shows you where they come from.
So should that be,
Version of the miles to the, you go to hectares and then acres?
See, I know that they're acres, so I didn't put the square down there for you.
should that be attached to the memorandum of
Sure it can.
December 10? Okay.
Right.
Mrs.
Do I have
Mrs. King, do you have any questions?
No, I don't.
Okay.
The answer
Great,
is yes.
thanks.
Pardon me?
Yes, the
I just-
question, I answered a question.
Yeah, let me just ask you this then, so we can really sum up from the town's position here. As I understand it, then, you may reformat these letters and,
We intend to have this one-pager on town letterhead addressed to the board, and then make reference to the map that will be attached as an
Great.
exhibit, and take out square, and so it just reads acres, and have it signed by the town planner and by me.
that's great. That'd be very, very helpful.
And you'll have that tomorrow.
That's great. You can email that to me, so I'll have it in the office and
Certainly.
see Mrs. Fitzgerald. She'll get you my email address. Yes, Mr. Jeffrey Mullen has another question.
So, Alan Bishop works for the town,
Yes,
and he does these calculations.
yes.
Is he using data that is available to, for example, the Department of Revenue for the purpose of establishing cherry sheet calculations?
Yes.
And
Mass GIS data.
so he's not independently verifying, he's not independently tracing these lots, he's using the town's totals that if you were to seek an independent database that was available to the Commonwealth, for example, it could be cross-checked, that kind of thing?
Yes,
Or, yes, he is.
yes. The
So
data-
that there shouldn't be a question as to the size of the water body, for example.
As a matter of fact, the number that came from the state was lower that we had than what the state had. So we did go back and cross-reference in certain areas.
I mean, some of this information is readily available. The number of acres of the Blue
SGIS,
Hills
yes.
is well-known in town. But what I'm wondering in this procedure, what we would be looking at of whether or not this information on the math is just readily available, basic tax information that, or is it actually being independently calculated for the purposes of arriving at these conclusions?
It's actually a little bit of both. It's taking what our system is parcel-based.
Yeah?
One of the things that we have done through the assessor department is to take a lot of the individual town-owned parcels and group them.
Okay.
We've taken some of the state-owned individual parcels and grouped them. And that may make it easier for the assessor department because they don't necessarily have to chase individual lots for the state, the county, or the town when they own them. But realistically, they should be separated. We've been going through the process of taking and separating those out. We did go through the process of individual large landowners that have multiple parcels that did get put together. We did take and bring them apart so that we did remove the duplications that were in there. I know that the page that I just gave you that had the calculations on it, I know I originally submitted it to Mary, and I know I signed it the other day. So I know that one of the pages that you have.
I did see that
It's that
somewhere.
same page signed.
Okay, I think I have it.
Yep. That's it.
Mr. Mullen, do you have any other questions?
No further.
Okay. You have nothing else to add?
No.
Okay, Mr. Caggiano, why don't we hear off of Mr. Cram on the procedure that the town is employing here and.
Sure. So, Mr. Chairman and board members, I'm Nick Cram on behalf of the applicant, H&W Apartments. But I think you described your role here today as determining whether or not there's a bona fide issue. And I think that role, which puts you in the position of a gatekeeper, is very important, and particularly with respect to Chapter 40B, which is intended to promote affordable housing and to eliminate undue delay and expense. So this is an important role that you're playing here with respect to this issue, and I think that we can convince you and show you here tonight that on both of these issues, the town can't possibly meet its burden of establishing that they actually have met either of the thresholds at issue. As a preliminary matter, the first issue which Mr. Chairman raised is a procedural one, and I think that this one is going to be addressed, but at this stage we would object to the materials that have been submitted by the town on the basis that they haven't been certified by anyone as to how they were created, where the information came from, and how these numbers were actually calculated. To the extent that that issue is not resolved to your satisfaction, that in and of itself should be a reason that this issue should not go any further beyond the board. So secondly, I'd like to turn first to the 1.5% minimum land area threshold. As you've noted, we submitted our view on this, which was supported by the expert report of VHB Ralph Wilmer and his colleague. That report concludes that the town is, in fact, 21 acres short of its 1.5% threshold. And I think the easiest thing for you to do to see what you need to do here is to have me explain our objections to various parts of the town submission. So in sum, there are three major problems that we see with it, some of which are unavoidable. The first is that it counts units, including the Fuller Village units that were newly added to the list that were not on the SHI inventory as of the date of our application. The applicant's initial submission to the board was November 6th, and the regulations clearly state at section 5603B in the final paragraph that only sites of SHI eligible units inventoried by the department were established according to 760 CMR 5603-3A as occupied, available for occupancy, or under permit as of the date of the applicant's initial submission to the board shall be included towards the 1.5% minimum. So that's the first issue. The units that were recently added of the Fuller Village parcels, and it's, I believe, 31 acres and 49 units that was added sometime very recently, but since our submission shouldn't be counted towards the town's total. The second issue, and
I'm sorry, can I just stop you right there?
Yes.
And just ask you this? Well, that may be a very proper argument and an effective argument, I don't know. But in order to make that type of determination, don't we have to have an evidentiary hearing on that issue? Because you've just got competing sides saying the opposite things. And we, to have that type of hearing would...
Mr. Chairman, I think we actually said the same thing. I heard from Ms. O'Donnell that, in fact, these units were just added to the list. And
We're not counted on her materials.
no, they are counted.
You say they are, but I thought she said they weren't.
Not that I counted the first part of Fuller Village, not the second.
In other words, aren't we going to get into
That was on
it?
the other argument, that was not on the 1.5, that was on our planned production.
Okay, well, maybe it's a misunderstanding, but if you look at the two-page submission, I believe that 1372 Brush Hill Road and 1399 Blue Hill Avenue are two components of Fuller Village development. And the second one was just added to the list in what was published on December 5th, and that did not exist
You
on
mean the
that.
1399 Blue Hill Avenue?
Yes.
Okay.
But they were submitted to DHCD in July.
Mr. Chairman, could I maybe respond to helpful?
Sure, that's right.
In the town of Bourne, it's called In the Matter of Chase Developers. It was an interlocutory appeal. I represented the town of Bourne. And it was clear that you count units that are in the pipeline. The fact that DHCD might take forever to certify units shouldn't work against the community. My understanding, and I'm sure Attorney O'Donnell can clarify this, is that the request for certification occurred well before this application was made to the town of Bourne.
Okay.
And just to respond to that, the new regulations leave no doubt as to this issue, and they say that only sites of SHI eligible housing units inventoried in the past tense by the department shall be counted and included towards the 1.5% minimum. So, but that's only one issue, and I think even without that one, we can convince you that it's
Sure,
not
why don't you
necessary.
proceed with your second and third issues, but my suggestion is that we be as brief as possible, because I think what we're going to find ourselves in a position of the town saying one thing, you're saying another thing. Your consultant, you're obviously articulating your consultant's considered opinions here, and without getting involved in a 2 or 3 day evidentiary hearing to determine the specific facts and the bona fides of all of these things, we're not going to be able to make that type of determination. And I think we're going to come down to the position almost necessarily that that type of technical argument, which is an appropriate argument for you to make, is probably best made to the department, who are probably more skilled and knowledgeable fact finders on these issues than you'd want us to be making as a Board of Appeals that generally decides variance and special permits matters. But we're delighted to hear from you.
And your point is well taken, and I fully understand.
How do you answer that argument in a...
And I don't intend to weigh our experts' report versus what the town has said, but I can point to the regulations and show very explicitly how what the town has put forward is wrong. And it's wrong to such a degree that it puts the or the SHI unit land area in the town clearly below the 1.5.
Why don't you continue with
Okay.
the presentation? Sorry to have interrupted you.
No, that's quite all right. So the second issue relates to another provision of the regulation. Actually, it's the same paragraph. So if you look at the regulation, section 5603B, and in the very last paragraph before section C, and in the last sentence of that paragraph, when it is talking about SHI eligible sites, it says, for such sites, that proportion of the site area shall count that is occupied by SHI eligible housing units, including impervious and landscaped areas directly associated with such units. And so that says two things. First, if there are areas Other than impervious and landscaped areas that are directly associated with the SHI units, those must be excluded from the land area calculation. And it also says that if there are units in a development that are non-SHI eligible housing units, that there has to be a proration for the land of the development.
And you contend the town has not done that here?
The town hasn't done that. I think we heard that the town acknowledged that, at least with respect to some of these. I'm sure they do that with respect to all of these on the record. I can point to two, which clearly demonstrate that they have not, and that in and of themselves push them below the threshold.
Which two?
1372 Brush Hill Road and 1399 Blue Hill Avenue?
So all just the Fuller Village units?
Yes, if we look only at those.
Mr. Chairman, could I?
Mr. Whitten, of course you can.
Again, my brother is ignoring the one reported 1.5% case out of Weymouth, even though it predates the 2008 regs. It's a rental project. You count all of the units, just like you would towards your 10%. And unless there are facts before the board as to the specific land area that is available for further development, the town gets credit for the entirety of the parcel. The HAC went to great lengths to distinguish between 1.5% and the 0.3% consistent with local needs status, and made a distinction between the 0.3%, which gives protection for a year, and the 1.5% protection. Thank you, Mr. Chairman.
Okay, your comments are well noted, Mr.
Thank you, Mr.
Whitten.
For the record,
Mr. Green.
yes.
Go ahead, if you want to reply.
Briefly, as Mr. Whitten recognized, the case that he cites predated the regulations which changed the playing field, and now the regulations are black and white, and they tell the board how to perform the calculation. I've done a very quick worksheet that shows, if you had done the proration, how this is calculated, if I may.
Of course you can.
Thank you.
Do you have a copy for Mr. Whitten?
I do, I think. Let's see, we'll start here.
Thank you.
You can-
Okay, so if you look first at 1372 Brush Hill Road, the total acreage of that development is 29.379 acres. Along with the materials that we submitted in our letter a couple of days ago, we gave a copy of a special permit, which indicates that there are approximately 10 acres of wetlands and a ball field in that development, neither of which would constitute impervious or landscaped areas that are directly associated with such units. And for example, the ball field was provided not for the residents of the development, for the town in general. It was under control of the Department of Recreation.
Oh, okay.
So you take the 29 total acres and you subtract 10 and you get 19,379. Then if you look at the whole development and the language of the regulation that I cited, there are 33, as the town has indicated on its list, SHI eligible units that have been inventoried, out of a total of 166 units. And that means that if you prorate this, the count towards the land area minimum is 3.85 acres, not 29.379 acres. Very similar calculation with respect to 1399 Blue Hill Ave. There, the total parcel is 31.93 total acres. I believe there's wetlands on that site too, which I can give you a little bit of information about, but we don't know how much at this point. But it doesn't matter, because there you have 49 SHI inventoried units out of a total of 153. If you prorate the acreage of the site pursuant to the regulation that I cited, you get to 10.23 acres. So now the difference between what the town had used, the total acreage, and the prorated acreage has to be subtracted from what the town found its total SHI land area to be. And if you add that up and subtract it, the total to subtract is just under 50 acres. It's 47.299, which if you keep falling down on this piece of paper. And if you subtract that from the 93 acres that the town found it needed to satisfy, or that the town said was dedicated to affordable housing, you get a total of 46.5 acres, which is just about 6.75 acres less than what the town itself says it needs to hit to make the 1.5% threshold.
Okay.
So on that basis alone, without looking, and I could go further, and we could have Mr. Wilmer speak to his report and how he did his calculations, but without even getting into the he said, she said problem, just straightforward application of the regulations, the facts put forward by the board, dictate that this issue should not go any further than this board.
Okay.
I don't know if we also want to speak on the plan issue.
The housing production plan? Yeah. Sure. So it's a surprise to me that the housing production plan is a topic of discussion tonight. When we had met on December 2nd, my understanding was, and the only conversations I've had with town council, is that the issue before the board tonight was a 1.5% land area issue. So I'd like to, we're not prepared to, or haven't prepared to discuss this. We haven't analyzed the numbers. We don't know what they are. But as a preliminary matter, I'd like to know what the town's numbers are, if you have them handy and would provide them, what the town numbers are to calculate their recent progress to as a statutory minimum.
Well, I certainly don't have them. The only materials that have been submitted regarding this matter is the October 28, 2014 letter, which you have.
Okay, so
So
then, okay, then I maybe a little bit.
you may want to be content to rely on this letter and not open up a can of worms, but I leave that one up to you.
Sure. So, if I may, Kathleen, are you suggesting that because the new full units were added and therefore consistent with the housing production plan, that therefore you've met the minimum and can deny the application based on satisfying the goals, the year one goals on the housing production plan?
Yes.
It is. Okay, so my understanding under the regs is it's not when the units are added, but it's when DHCD certifies the housing production plan as to when the board would have a regulatory basis to deny an application based on the housing production plan. And has the housing production plan been certified?
I believe it has, but.
The housing production plan has been approved. The letter for certifying those
Units.
units has been sent to DHCD.
Can I speak on this for a second?
Sure you can. Why don't you identify yourself for the record?
Hi, I'm
please?
Lynn Sweet from LDS Consulting.
Sure, welcome back to the board, Ms. Sweet.
Thank you. This is very easily resolved. The DHCD publishes on its website all housing production plans that have been certified. The plan would need to have been, I believe, certified again when we put our application in, and if you go to the DHCD website tonight, you will not see that Milton's plan has been certified. There has not been a request from the town to certify the plan. If the town were to put in such a request, the state would have a number of days, 30, 45 days, to look at that. So for that reason, we feel that this is a non-issue.
Right, so just to summarize, the trigger is not approval of the new units being added to the SHI. It's the trigger is the certification by DHCD to support a denial of the application based on the housing production plan.
And I'm sure we'll see that in the materials that you file with the department. Do you have anything else to add, Mr. Casciano?
No, not to that.
Okay, Mr. Mullen, did you have a question? No, okay. Mr. Whitten,
Mr.
please.
Chairman, two quick comments. One is, I appreciate my brother's comment about being surprised, but the surprise really is that the board only has 15 days to respond to something of such magnitude. So the town has done nothing wrong by raising whatever issues it needs to raise. With regard to Attorney Cram's comment about the wetlands, I mean, how ironic that they're saying to the board, you have to subtract out wetlands that you can't count as part of the denominator because the regs don't allow you to. I mean, talk about an ironic catch-22. The regs don't say you can't subtract out wetlands. Maybe the wetlands are part of the landscaping plan for the project. Maybe the wetlands are part of the open space component. The applicant will always tell the board that the wetlands are part of the ambiance of the development. So it's simply wrong to say that you have to subtract out the wetlands, which are included in perhaps the Brush Hill Road project.
But to make that determination, you'd have to specifically look at each individual project and then make specific and particular findings of fact and determinations in order to nuance that type of evidence. Is that true? Okay. Mr. Casciano, do you have anything further to add?
I have nothing further. Nick, do you have anything further? No.
Okay, fine. So, Mr. Mullen, are you ready to address this issue?
I'm ready when you are, Mr.
Okay.
Chairman, always.
It seems to us, unless anybody else has something to add, and I don't see any hands out there, that we're left with the basic issue that Mr. Graham mentioned, whether there's sufficient gatekeeper bona fides here to allow the, to warrant the board, a better way, but to warrant the Board of Appeals to submit the materials to the department which Attorney O'Donnell has outlined. And I think Attorney O'Donnell has indicated that she's going to make some technical revisions to the form of these documents, perhaps to try to resolve some of the technical authentication issues and the like, which Mr. Cram mentioned as part of his presentation. But otherwise, the substance of what the town is suggesting is before us in these documents. And so the question seems to be whether the town has carried its sufficient minimum burden to warrant the board to send the letter to the applicant and to have this matter go to the department for consideration within, I think, 30 days after the applicant has had an opportunity to file whatever rebuttal materials necessary. So my question is, Mr. Mullen, do you want to address that issue?
Oh, you asked me that.
I just did ask you that. You can defer if you'd prefer to have Mrs. King.
No, I thought maybe you were going, this is going to be one of those where you exercise your chairman's prerogative.
Well, if you want me to, I will.
No, it's always your call, Mr. Chairman, you know that.
I talk a lot at these hearings.
You
So
do.
I always prefer to have other board members weigh in, lest it be considered I'm making opening statements, questioning witnesses, and then telling the board how to vote. You know, I could never tell you how to do anything, Mr. Mullen.
So I spent some time with the regulations and the statute. This is not my area either. I have to say that I might feel differently if we had more evidence in front of us in terms of the particulars of Fuller Village, for example, and whether or not the actual way to read the regulation and how to back whatever it is out and how the calculations are done. I just don't think that we've got enough of materials, and we haven't heard enough evidence, and we haven't had the kind of robust discussion that we would typically be in front of this board to make the determination. But I say that knowing that that's not really our role here. The question in front of the board is whether or not we don't have enough evidence to meet the minimum burden that the town has put in front of us, that we could consider that a denial of the permit or the imposition of conditions or requirements would be consistent with local needs under the statute and the regulatory requirements. And I think the town has met that burden, if only to make certain that we properly adhere to the statutory requirements and the regulatory requirements. I feel confident that should be submitted to the Department of Housing and Community Development for the purposes of them making the final determination. And it seems to me that that's consistent with the regulations, and it's consistent with what we've heard tonight.
Thank you. Mrs. King.
I agree. I really can't add anything to that.
Okay. Well, I agree with my colleagues, as you may expect. It seems to me that this is a very highly technical area of the law that Ms. O'Donnell and Mr. Casciano and Mr. Cram and your consultants know very, very well. And it's a type of technical matter that I think if the board got involved trying to weigh these different issues on each of these particular applications, I think would actually inhibit the progress of your project rather than advance it. I think would be doing you a disservice because we would be here for hearings on hearings, whereas some arguments that you'd make before us would listen to and try to consider. If you made those arguments with skilled administrators at the department, you'd be stopped short, and they would get right to the quick of this. It seems to me from reading the materials that Ms. O'Donnell has submitted, as well as your letter and the consultant's materials, that this is the type of matter that can be dealt with dispatch by skilled administrators in a far more effective way than the Board of Appeals. And if we ended up coming up with a curious or a mysterious decision, we could end up causing you more harm than good, in my view. So I do think the town has met its minimum burden of showing that their petition here is being made in good faith. It's not being made to delay the proceedings at all. I don't think it will delay the proceedings at all, because while you have 15 days to respond, you already have a very excellent basis, and to the extent that you want to start going into some of these individual projects and completing the record to rebut what the town has done, that's obviously up to you. But I think you could do that in far less than 15 days and present a compelling case for the department to make a determination. And then depending on what the department did, who knows whether there'd be an appeal or not. So I actually think that having this matter proceed with an adjudicator, or at least an administrative non-evidentiary hearing at the department is to your advantage and not to your disadvantage. But that's my own personal view. You know what it's like. I've never been up to the Department of Housing and Community Development, and I never intend to do so. Okay, so with that having been said, I think that the board has found that there's sufficient basis for the board to at least submit the letter to the applicant and to the department. I intend to do that tomorrow, Monday at the absolute latest, and I'll obviously send emails to everybody, and probably FedEx to people, so everyone will have a feeling. My letter to the applicant and to the department is going to be the notice filing letter. I am not, this board is not going to get involved weighing the merits or making arguments or statements that would advance either the town's position or the applicant's position. I think you're both represented by excellent and skilled and vigorous counsel, and that's not our function here, other than to say we found a sufficient minimum basis for the letter to be filed. So that's number one. The second issue, that it's somewhat unrelated to that, but I did want to discuss it tonight. And even though the filing of this decision stays the 180-day time period, I'd just like to know from the applicant, and you don't have to, I'm not trying to pin you down tonight, but pending this hearing this evening, I have intentionally not sought out any peer review on your application with a traffic engineer that we discussed last time, or with the, I'll call it the land use planning engineer that Mr. Mullen suggested that we consult with. And so I'm always reluctant to spend a client's money and Mr. Holland's money, because you'd know better than I what it would cost to have that done. My guess, it may be $10,000 or $15,000 to have that type of review done by both of the consultants in a ballpark sense. And so I don't want to go forward and have that done and find that you have bad luck at the department, and Mr. Holland's money has been spent to no avail. That having been said, if Mr. Holland, in his considered opinion, wants to try to save time on this project, and while this matter is pending at the board, wants that type of site plan review to go forward, so that perhaps it would be ready at sometime in January or maybe March, rather than delaying that. I certainly would be willing to do that, so my just comment is just to talk that over with Mr. Holland,
I
and,
want to proceed with it, yeah.
well, why don't you talk with counsel in private, and you can come to whatever conclusion that you want. But if that is the applicant's preference, I will start with that starting tomorrow and see if I could get that lined up, knowing full well that if you have bad luck at the department, we'll call to a screeching halt any peer review, but your funds may have been spent.
That's fine.
Okay, and you just let me know. Shoot me a short letter or an email to that effect. So, other than that, I don't think there's any other official business to come before the meeting, so that, do you have anything else, Ms. O'Donnell and Mr. Casciano or Mr. Graham? Okay, so with all of that being said, we're going to send this letter to the applicant and to the department either tomorrow or Monday at the latest. And we'll see how that goes. And then when you get a decision from the department, we'll try to reschedule things here at the board. Just for your own planning purposes, though, you should know that December is always good, January is good, February is very, very bad for the
Town
board.
meeting.
Okay? So that we're probably looking, if you got a quick determination at the housing, Department of Housing and Community Development, you're probably looking at and we go forward with peer review, you're probably looking at the very earliest at maybe the third week in January and maybe the fourth week, but that gets a little late. But even if the peer reviews weren't ready, we have other issues that we can deal with. So, and then we'd be going over into early March. Okay.
Should we tentatively schedule?
Well, I hate to schedule a meeting because we don't know what the department's going to do here, and we don't know what the time schedule is. Do you prefer, we could schedule a meeting and then postpone if the matter's still pending. Would you prefer to do that? Okay. Ms. O'Donnell, do you happen to have your BlackBerry or whatever you have there? And, well, Ginny, did you bring your stuff with you?
Don't have it today.
Mrs. King. Okay.
Because I'm assuming that we're going to do it over Council on Aging?
Over at the Council on Aging,
Yeah. Just so you guys will have more people?
are people trying to send us a message? Or- I know that's not true. What looks good from your
Unless you
perspective?
want to attempt to do it here, it's up to you.
Well, I'd rather do it in Town Hall than Council on Aging, but on the other hand, if it's not available.
It's not that, John, it's a space issue, and there have been people who've expressed the desire to personally attend.
And to be seated during the progress of the meeting. Okay, that's fine. How many seats are at the Council on Aging as opposed to here?
I've never been there, so I don't know. There's more than here, though.
A lot.
A lot more.
Well over 100.
Okay, then we'll try to do that. I was hoping somebody would say the Milton Public Library, because that may be a little fancier ambiance. But what looks good for you and Mr. Cram?
On Tuesdays, preferably.
Tuesdays, let's say the,
20th?
gee, I think that second week in January is just much too soon, unless you think you're going to be filing with the department, middle of next week or something. But I'd say something during the week of the 19th. We have Martin Luther King birthday on the 19th, so
20th?
How about the 20th? You said Tuesdays, right?
Yes.
Yeah, so Tuesday the 20th.
That's great.
Does that work with you, Paul? Yep. Lynn?
Absolutely. Yeah. I'll
okay.
be done.
And Mr. Mullen, how are you on the 20th? Okay.
'20th of January?
20th of January, Tuesday.
Okay.
And Ginny, you think you can do it? Do you want a fallback date, just in case you can't do it?
No, I'm reasonably
Okay,
certain with that.
so we'll do the 20th of January. So what we're going to do is we're going to continue this hearing till the 20th of January at at the Council on Aging tentatively, but just check that out, folks, with the,
Yeah, check on the website.
look on the town website, and we'll tell you exactly where we're meeting, and that will be at 7:30?
Excuse me, Mr. Chairman,
Yes, sir.
Conservation Commission meeting on the 20th.
Where are they meeting?
Here.
In this room.
Okay. So that's,
This map.
Giano can't appear at the Conservation.
well, that was my next question, whether the Conservation Commission was conducting the,
We're on this, we're on next week, but I don't know when we're going to be on again. We may be done.
I don't think we have something scheduled for January 20th currently.
well, I think the spokesman may be a member of the
Sure.
Conservation Commission, if I remember. Let's check, see if Mary has any idea. If it is, it's just easy to
The
bump it.
20th is Concom, but it doesn't give a schedule of what's hearing that night.
Okay, so let's bump it a day or two, don't you think? Keep it moving, and,
A day or two, it has to be Tuesdays though, right?
no,
So-
it doesn't, well,
Oh.
just,
Well, at the Council of
oh,
Aging.
okay, well,
I know Mondays and Wednesdays are booked, yeah.
Does the Concom meet just once a month?
Yes.
Yeah. Well, I guess the next date is Tuesday, the 27th.
I knew you were going to say that, but you can be in deep trouble with my wife. Her lawyer may be contacting you. I think I can do that, but I avoid that last week in January. It's, well, why is the Council on Aging only available on Tuesdays?
Every Monday and Wednesday night they're booked for something, I don't remember what it is. So they mentioned Tuesday.
So what's wrong with what's wrong with Thursdays?
You could try the library. What about the library on Tuesday?
Problem with the library is you have to be out by 9 o'clock.
That's
There's
fine, but
nothing
then you
wrong with
start at
that.
6 o'clock. They may be doing us a favor.
Start pushing it a quarter hour.
Does it
Can we
make,
bump anybody that's in there? If there's anybody on the calendar, can we bump them?
Here. We don't have that. I don't have access to their calendar right here.
wouldn't it be preferable then to have something on, if you've got Concom on the 20th, to do the 22nd at a place to be announced, whether it's Council on Aging or the library or we have public schools here that have big rooms that presumably we could use. I don't know, but and then we won't get involved in the craziness of that last week in January.
And then I can post it on the website or where it's going to be.
Yeah, absolutely.
So 7:30 on the.
So how's the 22nd, folks? Does that make any sense, Jeffrey?
What day?
22nd, Thursday, the 22nd of January?
I mean, we do need to check with Jim, but
Yeah.
he's not gotten any more trips.
That still sound good for you, Virginia?
I have something else, but I can,
Well, you can bring the people to the meeting. And they can
they could sing for
watch.
you.
Okay.
What's the singing?
We're doing good here. How about you, Mr. Caggiano? 22nd's good. Okay, so what we're going to do is, we're going to continue this meeting to the 22nd of January at 7:30 at a place to be announced. Look at the website, and we should know well before the 22nd whether that meeting is going to be held, and if it's going to be canceled because the state agency still has the materials, we'll publish a notice on the website, and then we'll see you in March. Okay, and you get back to me on the peer review. Okay, so with all of that, folks, we're adjourned. And thank you for coming tonight.